Okay. All right, good morning, everyone. I'm Steve DeLaRoche. I'm the Special Code Enforcement Magistrate for the City of Daytona Beach Shores, and these are code enforcement hearings. The way the hearings are conducted is the city has the burden of proof. They go first. They can present testimony and evidence, evidence meaning documents, photographs, whatever they need to present their case. Then it is your turn to cross-examine them. That is, to ask them questions. It is not your turn to tell me your side of the story. After the city has exhausted its case, then it's your turn. You can testify on your own behalf, you can call witnesses, you can show me photographs, you can show me documents, whatever you need to prove your case, and then I will render my decision. If at any time during your case, not somebody else's case, that you don't quite understand what's going on or you don't know what to do, I can't tell you what to do, but I can certainly tell you your options. You can do this or you can do that. So I want to make sure that everybody understands what's going on and that everyone has a fair hearing. Okay, the first order of business is to approve the minutes from the last meeting. Is there anybody here that has good cause as to why the minutes should not be approved? Okay, seeing no one raising their hand or protesting, the minutes from the last meeting are approved. The first case is property owner 2120 South Atlantic Avenue, LLC, which is case CDEF 2020-95. Is there a representative here from the property? Yes, and you are, sir? And what was your name? Okay, all right. And Ms. Herstein, you're representing the city?
Yes, Your Honor.
Okay. Gentlemen, please come forward to the front row. Okay. Last time Mr. Storch was here, and we started the hearing, and the city put in its evidence, and then it was obvious to me that Mr. Storch didn't have the tools that he needed to even do anything, and I granted a continuance after the city had put in some testimony and all of their evidence.
That's correct.
Okay, so you're up to speed?
Yes, yes.
Okay. All right, Ms. Herstein, do you agree with what I just said?
I do, Your Honor. I don't know if it's appropriate, so I'm asking you. The items that were stipulated to are all as they were stipulated to in your agenda packet. There are 3 additional inclusions which the city would like to request to be added to the evidence, and that is an updated date affidavit of costs.
Okay.
And also the order continuing the last hearing, and then an order continuing the last hearing amended. So those 3 documents have been added. That
Okay.
order had the May 15th date of hearing on it. Somebody from Mr. Posey's office pointed that out, and a new one was generated. It was good.
Okay, did I already sign those orders?
Yes, Your Honor.
Okay, I thought you'd sent them to me. All right, why don't you raise your right hand and we'll get started. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. All right, and Mr. Posey, I've already signed the continuance orders, and since the continuance happened last month, it is.
Well, and I was just, for the record, we have no objection, and we
Since
also to that.
you asked for it, I'm assuming you don't have an objection to the continuance. And it'd be really hard for me to go back in time and undo it, so we're just going to go forward from there. Okay.
I have one more request, Your Honor, and
Sure.
that is that an acknowledgement that the pagination has changed in places of the
Okay.
packet due to the inclusions of those 3 items.
All right.
And also, I want to reiterate that because the documents were stipulated to, we did not present the full presentation that the city would normally do, but I wanted to make sure that you knew that all violations, pictures of all violations, slides are available if we need to refer to them for any reason, if it's desired by you, and also violation lists and when they became compliant are available.
As you, last month, I read every single page, and last night, I again read every single page. So I'm familiar with it.
Thank
I
you,
don't
Your Honor.
think, but it's your
They're available.
presentation. I don't want to limit you to whatever you feel you need.
As they were stipulated to, I don't feel the need to go through them one by one. I want to just make note that they are available should we need to refer to any one particular violation or violations.
Okay. Mr. Posey, do you have any questions for Ms. Herstein?
I do not.
Okay. So,
Thank you.
I guess you're resting for now?
Yes, Your Honor.
All right, thank you. Gentlemen, why don't you come up? Who do you have with you, sir?
Good evening, or good morning, Your Honor. I have the property owner, that's the one that attested in the affidavit you were providing.
Joseph Ernest.
Yes, Your Honor.
Okay. Mr. Ernest, I'm assuming you're going to say something, so would you mind raising your right hand and be sworn? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Gentlemen, before we get started, I'm going to tell you the same thing I told Mr. Storch. The way these fines are imposed is it's days that you are out of compliance times the amount of the day that you were fined equals the amount of the fine. I cannot take into account, for lack of a better term, mercy or unreasonableness. What I can do is I can remove days. So what I'm looking for in your presentation are days that you were not responsible for the delays. For instance, if you applied for a permit on June 1st and the city didn't return it back until June 14th, and there's nothing you could do for 14 days, I will remove those 14 days. Okay? Having said that, do you two need a moment to confer?
I think, Your Honor, that the affidavit outlines those days. I just don't have them, I guess, packaged in a way that I think is the way that you were expecting, so.
Well, if, for instance, you want me to remove 542 days,
Understood.
I need 542 days documented so that I can remove it,
Understood.
rather than a period of time, no offense, like October to January. I would, while I will, it's my job, count every single calendar day, you have a better chance of convincing me if you have a set number of calendar days that you want me to remove.
Understood.
Would you like a minute to confer? Okay, I figured. Like I said at the beginning, I want this to be as fair as possible, and $297,000 is a tremendous amount of money.
Yep.
So I want to give you every opportunity. Fortunately, we have another case. I'm going to,
That's fine. If you'd like to move to that case, then.
I'm going to. And if you two need to step out and then come back in, or whatever you want to do, I want to give you as much of the benefit of doubt as possible.
Thank you very much. I appreciate it.
You're welcome. Okay. You okay? You ready to switch gears?
Yes, Your Honor.
Okay. All right, next case is property owner J.K. Daytona LLC, case FCDEF 2024-42. And Ms. Herstein, you're here for the city on this one as well?
Yes, Your Honor. I will be joined by Crime and Fire Prevention Lieutenant Norma Metters.
Crime and fire prevention.
It's quite a title.
I'd really like to know what he's doing to prevent crime. I get the fire part after reading the file, but, all right, this should be very exciting. He doesn't seem to be wearing a cape for both jobs,
He
but,
does. It's just invisible. Your Honor, I'd like to ask that each of the documents included in this PowerPoint file, whether presented during the hearing or not by the city for this case, be accepted as evidence, most of which have been provided to the special magistrate, and all of which have been provided to the respondent's representative.
okay, I forgot something very important. Is there a representative of the respondent property here? Okay, could you please come in front? And ma'am, what is your name?
Shamira Muhammad. Excuse my voice is gone today.
Okay. I think I have your name in the file.
Yes, Your Honor.
Okay. And, ma'am, were you provided with a copy of the packet?
Yes.
Okay. And Ms. Herstein, did she have the necessary paperwork to represent the property owner?
Yes, Your Honor, she does.
Okay. Do you have any objection to the introduction of the packet into evidence? Okay, then it'll be received into evidence.
Thank you, Your Honor.
You're welcome.
This is a first compliance hearing, which was brought before Your Honor, His Honor, for an initial hearing January 16th of this year. The property was found in violation, was given until February 18th to restore the fire alarm system, and until July 16th to restore the fire sprinkler system, or fines of $250 per day would begin. The property was not brought into compliance by the first ordered compliance date of February 18th, so an affidavit of non-compliance was generated, and you can see that on, generated and signed and notarized. You can see that on page 4B 1314. Compliance regarding the fire sprinkler system being operational. Compliance regarding the fire alarm system being operational was achieved on March 19th, and an affidavit of compliance partial was generated on that date. You can see that on pages 4B 15 and 16.
Right.
When Lieutenant Metters and Inspector Derek George, Fire Inspector Derek George, were there for an annual fire inspection less than a month later, that was April 11th, the fire alarm panel was sounding alarms and communicating issues, and communicating basically that the fire alarm was again non-functional. So on that day, another affidavit of non-compliance, second incidence, was generated and signed, and you can see that on pages 4B, 17, and 18. We're here to establish non-compliance beyond the findings of fact order date, and to impose accrued fines as a lien for both the initial 28 days of non-compliance and then all days since that second incidence of finding non-compliance for the same issue of April 11th. So the 28 days prior, and then from April 11th to now, and continuing to accrue at $250 per day. I would like to, I do have a full recommendation for that to offer, but I would like to call Crime and Fire Prevention Lieutenant Metters to the podium, please.
Okay, Lieutenant Meadows, please raise your right hand and be sworn. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay.
Thank you, Lieutenant. Would you please?
Just for your information, what I'm very interested in is I saw that they tried and failed to get things working, and I want to know why it failed. Okay?
Understood, Your Honor.
I don't know if it's their fault or somebody else's fault.
Understood. Lieutenant, if you wouldn't mind stating your name, position with the city, and how long you've been with the city.
My name is Norman Metters. I'm a lieutenant with the City of Daytona Beach Shores Department of Public Safety. I am approximately 18 years now.
Thank you, Lieutenant. Have you reviewed the documents submitted into evidence for this hearing?
Yes.
Thank you. Are they identical copies of any that you created for this property?
Yes.
Are the facts presented therein and verbally today consistent with the facts of the case as you know them?
Yes.
And are there any corrections or clarifications you'd like to make? Thank you, Lieutenant. Have you been back to the property since the initial hearing?
Since the initial one in January, yes, about approximately 15 times, and my last one was in May 7th for a quick meeting with the manager, Shamila, and the alarm contractor at the time, and that was my last time since.
Thank you, Lieutenant. Currently, how many hours per day is the property required to maintain an independent company's fire watch?
Currently 24/7.
And is that true for the entire time since that initial hearing?
When the alarm was in service for that 3 to 4 week period, it was reduced to an 8-hour overnight watch for sleeping hours only, and then put back on when the alarm went back into failure.
I see, thank you. And so since that April 11th date, they've been consistently on a 24/7?
Yes, 24/7.
Okay. And how do they demonstrate that to you?
They have a third-party company that comes in and provides the independent service to walk the floors. I believe it's CBC Hospitality is the company who provides me the logs every morning by 9 a.m.-ish.
And I heard ish, have they been doing that as you require?
Yes, daily, yes.
Okay, so you haven't had to chase them for those? You've been receiving those?
There has not been an issue with that, no.
Thank you, Lieutenant. Is there any other information that you'd like to present to assist the magistrate in making a decision today? He did bring up a particular area of interest that he had. Anything that that you think that we haven't put on the record that we should add. Otherwise, please do address the question that he raised.
At this time, no, but answer your question about the alarm, I see there's a alarm company representative. He was here at that time. He would be best suited to answer that. I can give you a well-rounded answer, but the system, from what I believe, is due to old wiring and so forth, and you're mixing new with old, and it's not going to mesh very well. He could get a better answer, the more technical answer to that, but more than likely that's the cause of it.
Well, the question I have is they supposedly fixed the alarm, and then you did an inspection,
Yes.
and it wasn't operable. Should they have known it was not operable?
That would be a question for him. I'm not a technician or a fire alarm contractor on that, but going through the gamut of what they did, so I did a 100% test on everything that they installed or fixed to get it working. They put a whole new alarm panel, went through the test of what I'm required to do per fire code. Everything passed per fire code of what I'm allowed to do and what I'm qualified to do. At that point, it's out of, I unfortunately can't do any more than that. And then when I showed up, weeks later, just doing a normal annual inspection, the system was going haywire at that. For the cause of that, I couldn't tell you, only a technician would be able to.
Okay, I'm not so much interested in the cause of it as should they have known. For instance, if I go to set the alarm at my house, it will say not operable zone 6, which means somebody's left a window or sensor or something ajar, and I have to go slam the window, and then everything lines up in the system alarm. I'm looking to know, should they have known it was not going to work? Because I'm being asked to find them an additional 28 days, and if there was no way they would know, I'm not going to find them the 28 days. If it's something they should have been aware of, then they're going to get the 28 days. Yeah.
Hard to say. In my opinion, yes, they should have known.
Okay,
But-
and why should they have known?
I'm sorry.
Why should they have known?
They've been working on it, and they're the contracting company who has the experience in it.
Okay, let me ask a further question. I'm interested, should the management of the hotel have known, not so much the alarm company?
Hard, I don't want to put that.
I'm never going to get you to come back here again, am I?
It's hard to say on a manager per se. It would be no different than me. It's hard to say that they should have known. If the bells and whistles are going off, yes, that there's an indicator there, and I don't know when those bells and whistles were going off per se, but in the end, yes, everybody should have known there was issues. Since there was issues at the beginning, there's still going to be issues until everything is completely replaced.
Okay.
May I, Your Honor?
Yes.
Is it your understanding that the 28 days that that we're initially requesting fines for is the time period between the magistrate's ordered compliance date of January 18th and when you were able to first deem them compliant almost a month later, in February? That's the 28 days. They knew that they weren't compliant yet. We knew that they weren't compliant yet. So that's the initial 28 days. And then from that date, in March, to that April 11th date, we're not asking for fines for that time period because we understood or thought they were compliant. We're not asking to try to determine if they should have called us sooner because their alarm panel was now sounding. Was it sounding on the date that you went and indicated compliance in March? March 16th, I believe?
March 19th, I believe it was the date. That was the date that I finalized it. It was working properly at that time. After that, it could have went haywire the next day, and I don't know.
Okay, I appreciate you clearing that up. Thank you.
I did speak incorrectly with the dates. The hearing was the 18th, was January 18th. They needed to become compliant by February 18th. The 28-day period is the time from the ordered compliance in February to that March
Okay.
compliance date, where we have an affidavit signed and presented in the notebook for compliance. And it did appear at that time you were able to sign off on it?
Yes.
Okay, so it appeared compliant at that time. And then April 11th was when you first noticed?
Noticed that it was, because that was my time that I had returned to the property at that point.
We're not asking that fines accrue in that interim period, although it is a valid question. If the alarm was sounding and lighting, did anybody notice that before then? But we're not asking for fines to accrue during that period.
Okay, I appreciate that, and thank you for clearing it up. Ms. Mohammed, do you have any questions for the lieutenant?
No,
Okay,
but can I say?
you will. I'll give you an equal chance, okay? I will sit here all day until everybody gets a chance. Any other questions for the lieutenant?
Yes, I have two more quick, though. Lieutenant, did they, as your understanding, or have you reviewed a renewed alarm permit application for this property?
No.
Okay, so for the work that needs to be done now to restore the alarm system, you haven't seen an alarm permit application to renew?
Not since this one has been closed, no, there has not been a new alarm permit application since then, no.
Thank you. And what about a fire sprinkler application? Because we are coming up on that compliance date.
There is a current issued permit for the fire pump that is, I guess, on order or ready to be installed or whatnot. I don't know the current circumstances of that.
Thank you. And is it your understanding that that fire pump, once it is installed, will satisfy their needs for the fire sprinkler?
Once it passes inspection and all that, yes.
Thank you. I have nothing further.
Yeah, it's something like the pump was installed in 1969 or something like that. That building is this old?
Yes.
Wow. Okay, I have, Ms. Mohammed, do you have anything else or any questions of the lieutenant at all? No. Okay. Thank you very much for being here, Lieutenant.
sir.
If you'd like, you can leave. It's up to you. You don't have to.
Yes, thank you.
All right, but I'm not kicking you out. All right, Ms. Herstein, anything else?
Not at this time, Your
All
Honor.
right, Ms. Mohammed, it's your turn. Good morning. Could you please raise your right hand? You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay? What would you like to say?
For my company, it depends, I want to say something. Just like you said, the property is 1969 built. So 2022 hurricane happened. That's the time we try to fix all the things. So the walls are down, the 92 rooms were down out of 132 rooms. We got flooded, and this is where that we start doing all the work. So that's the time we found out, like, a wiring. We didn't know the wiring was bad or how that works. We didn't know. So they fixed the fire panel was showing us the carbon monoxide devices were bad. So we replaced 132 of them. And then the other stuff is coming with it, the base and everything else. Then after that, everything went well. It's like Ms. Mom said, it was went well. And then April 11th, when he visited the property for some other reason, so we heard the sound, alarm was sounding. That's the time we called again to them, because we are not technical, like I said.
Right.
I had no idea what's going on. Then they found out the wiring was bad. That's the time then, so we are almost spending hundreds of $1,000s. My ownership is doing whatever they can do. So we found out they never been replaced before, like since the
Wow.
property bought it. We own like four years ago, my ownership bought the property, so without knowing anything. So I don't know, the inspection was well. Every year inspectors comes, inspect fire alarm, inspect fire sprinklers, everything went well. After 2022, that we found out this is what's going on. The property went through a major renovation, so 132 rooms we renovated. Everything was renovated, it's brand new, basically everything in the room. So that's where we found out the wiring issues. That's when Ms. Mohammed asked us to rewire the property. So that's what we are doing right now.
Okay.
So rewiring the whole property, it's not a simple job.
No, I imagine it's not.
Correct.
Particularly, probably, they didn't do things
From the
like they do now And it's probably not in conduit, it's probably in concrete and everything else, so.
Exactly. So they should have done it in the renovation happening. I don't know. I can't answer that question. But anyways, we are doing right thing. My ownership is doing so much money into the property, and we did a lot of, not even the money and the time and every time. So I am there at the property most of the time, 16, 17 hours there. So yeah, so we hire another company, third-party company. They come and do the fire watch all day long. So then we are paying for them to do the 24 hours. We are trying to do the right thing here. So that's all I can say. So if anything technical, you can ask him why they couldn't recognize. Because the first time we recognized, we needed to change the carbon monoxide devices and the bases, so which we did. And then the fire panel went, everything was okay. And then when they came for inspection, everything went well. And he basically checked you know him, so he went to every single.
Are you telling me he's picky?
Very much so. Every time he come to the building, tell me something is wrong with the building. So I am dealing with him, and then, so he went to every single room, every single floor, and everything went well. We were compliant and everything good. So April 11th, Mr. Norman came for something else, and then he said, it started sounding that day only. And then we found out, oh, something is wrong. And then it was going beep, 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 and a couple of rooms here and there. Then we had to call up to court again and ask I'm not technical. As he said, I have no idea what's going on with the fire panel. That's my chief engineer right here. So we call him to come back and investigate what's going on. That's the time they find out these old walls has bad wiring issues.
Right.
So then ownership said, yeah, let's change the whole wiring system. Now that's what we are doing. Just wanted to make sure that you understand what we're going through.
Right.
We just don't want our people to, or for all my employees to be unsafe situation, but this is what we are going on right now.
Well, the nature of this hearing
Yeah.
is to determine if you're in compliance.
Yeah.
The nature of the next hearing is to determine whether or not it's your fault.
Yeah.
And to remove fines if I choose to. So I can't give you a break today, but I can give you one next time you come see me.
I understand.
You understand?
I understand.
Okay. Ms. Herstein, do you have any questions for her?
Not at this time, Your Honor.
Okay. Are there any witnesses you'd like to call?
Sir, I have a technician from the up to code. They are the one who's doing my fire panel, so if you have
Okay.
any question for him.
Sir, what's your name?
Sean O'Connor.
What?
Sean O'Connor.
O'Connor. Okay. Mr. O'Connor, could you please raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. This is an adversarial proceeding, meaning usually the person that puts you on the witness stand asks you questions. Obviously, Ms. Mohammed's not an attorney, and probably the first time she's ever been in a proceeding like this. So I'm going to make it a little easier on her and ask you the questions that I want to know, okay? What I'm really concerned about is wiring, from what she's telling me, in the building is faulty and needs to be redone.
Correct.
How long is that going to take?
Currently, we're maybe about 50% or so done. All floors for the rooms have already been pre-wired, so new wiring has all been ran. The
Okay.
second floor itself is completely finished. First floor and fifth floor have some rooms complete, some rooms still needing to be completed. Third floor and fourth floor haven't been touched yet as far as bringing wire into the room and connecting them to the devices.
Okay.
But that's pretty much where we're at.
And you believe this will solve their problem?
Yes, sir. Yeah,
And
the
when
current
do-
wiring, again, as you stated before, it may have worked back in, the 70s, 80s, whatever, but with the current panels the way that they are now, they're so sophisticated that that old style of wiring causes more issues than it does, having the panel work the way that it's intended.
Could you go wireless?
No.
Okay. Just all curious.
I wish.
I guess it would make it a lot easier.
Uh-huh.
When do you anticipate being done?
Hopefully, all goes well, maybe within the next 2 or so weeks. It's mainly getting into the rooms and bringing the wire into the room itself. That's the most difficult part that we're encountering right now. Obviously, when they had their roof blown off and they had renovations done, some of the roof lines changed a little bit. And based on where the wiring actually enters in the room, now it's a little bit more difficult, but we're making it work. So.
Okay. Please keep track of the number of days that you're doing this and things that particularly may not be the fault of the hotel owner.
Correct.
Okay?
Yes, sir.
Ms. Herstein, any questions?
Yes, Your Honor. Mr. O'Connor, when were you aware that you did not have a permit for the work that you're doing?
This morning.
Okay. And when did your company give you an indication when they could obtain the permit, or when they would submit for the permit?
Messaged my office this morning, right after you told me, but I have not heard back from them yet.
Okay. And are you aware that you're not supposed to be working without permits?
Aware, yes.
Okay.
Did I know that there was not a permit submitted? No.
Okay. Is this something that you will prioritize? And
Yes.
Okay, thank you.
Ms. Mohammed, do you have any questions that I didn't ask?
No.
Okay, thank you. Appreciate it, Mr. O'Connor. Anything else you'd like to tell me, Ms. Mohammed? Okay, all right. And Ms. Herstein, you're looking for what, a number 7?
Actually, I believe it's number 11.
11?
Yep, requested order number 11.
Okay. I'm going to issue order number 11, which means I'm finding you not to be in compliance for 28 days plus from April 11th till now. Fine will run $250 a day until you are brought into compliance. You have to get the city to come out and inspect, and that runs the time. And you're looking for administrative costs of,
$79.93.
okay, $79.93 administrative costs within, can you pay that within 30 days? All right, please, thank you. Lieutenant Meadows, it is a high compliment when a citizen complains you're doing your job too well.
Yes, sir.
Okay, thank you very much for coming. All right, thank you, you're free to leave.
Thanks.
Okay, now, did the other group run away scared, or are they coming back?
Your Honor, would you like me to ask them?
Do you mind?
Let me set this back, and I will promptly go and ask.
All right. Who's the gentleman in the teal shirt wearing the other side?
Oh, Josh Hammerlin. He's our, I want to say new, but not really new anymore, but he's our esteemed building inspector. And he, I will get, eventually you'll hear the exact same kind of compliment that Lieutenant Meadows got about Josh.
I see, okay. All right, Mr. Posey.
All right.
You had enough time.
I had mad scribbles on paper.
All right, I mean, the question is, have you had enough time?
I think so.
Okay.
I think so, because the nature of what our position is going to be is, again, it's, a lot of this has to do with equities, and I understand how you framed it. A lot of stuff, of course, things being in his control, not in his control, hurricanes, et cetera.
Right.
But the purview of what you're asking, we did do that calculation.
Okay, good.
So, from our perspective, I calculated 1,133 days.
1,133 days.
Correct.
Is, okay, so you're saying that his fault was 57 days?
Well, I think that it would be the time frame from, maybe I misunderstood the duration of the fining, is
The
that?
duration of the fine when he was out of compliance is 1,190 days.
Okay.
At $250 a day equals $297,000.
Gotcha. And, yes, I am saying that 11, and I will walk through my numbers just so you understand what I'm
Okay.
talking about.
Not that I don't believe you, but okay, it's your presentation.
So, the first part that we put in this is the initial date of notice through the hearing of noncompliance, which would have been 288 days. Obviously, if he has no knowledge and he has no ability to make the corrective actions, then he's lost the opportunity of 288 days to even do anything.
Right?
And then the additional fine from post-fine, which would be January 19th, 2022, through October of 2022, which is what we are representing as his date of being brought notice of him being able to make corrective action. That would have been another 273 days from that date.
Okay, could you repeat? Why didn't he, 273 days?
From January 19th, 2022, which would have been your order imposing fines,
Right?
through the date he was made aware personally of the issue and looking to make corrective action.
Okay.
Because up and through that point, as mentioned in the affidavit, there was a manager in the LLC that was overseeing the oversight of this property, and clearly wasn't. That's really the long and the short. And once he was made aware of it and stepped in, that was, again, for the owner's opportunity to make the corrective action. So in our eyes, that would be due a credit on the fining from our perspective.
Okay.
The next number that we had was the January 23 through March of 23, and trying to secure the professionals to do this work, which we had 90 days allocated to that. Again, there's various days I guess I could point through from there up through the hurricane period, but again, the hurricane period is something we would also, again, allege is a credible action, because a lot of damage, a lot of work, folks are being pulled in all directions, and, again, there's certain priorities on which you have to do as, from your business perspective, but also from a property owner's perspective, and you can't be pulled in every direction all at once. And, I'm showing a period of 151 days for a 6-month period, and, trying to be reasonable. I would imagine that the damage has been far beyond that time period.
Right. This is unusual. Can I have you two approach?
Sure, of course.
Ms. Hurstein? I've never done this before in the code enforcement, of course, when I was on the bench all the time. I don't know how to say this, but this isn't working for me. This is too... I'd love to have a summary sheet of the dates and the days and everything. You just saying days is going to be incredibly difficult for me to follow. And I don't want you to think that I'm not paying attention or not capable of doing it. But this is $297,000.
Agreed.
It's a lot of money. I don't even know what the building's worth this.
Well,
So what I'd really like would be a summary sheet and a reason. Now, I know you're not prepared to do this, and I did give you a continuance last time. And I want to be as fair as possible to the city. And everybody's here today, but for lack of a better, Mr. Storch was here last time, you weren't, and we weren't prepared for what I wanted because I told him, and he neglected to tell you. Do you want one more bite at the apple on this to get it together with what I'm looking for, and that's a chart of why it shouldn't be held accountable for when his agent was given notice and he wasn't given notice? You're not making a suitable argument. You understand what I mean?
Yeah, I follow, and I guess, Your Honor, the problem I'm having is that a lot of this is going to turn on the equities. And, again, if we're taking the hurricanes and we're taking the nature of the value of the property and just maybe a fundamental disagreement about the code compliance and achieving compliance, a lot of that is just going to be, in my opinion, versus your opinion.
It's not versus my opinion. It's you have to persuade me.
Right, well, I understand.
And the city is very documented as to when contact was made and everything else. You're, how to put this nicely, not as precise.
Sure.
In order for me to remove a single day, I need to know why it's not your fault. You can't just say from this date to this date to find professionals and all that. I want to know why I should forgive that time period when ordinarily somebody would You know, if I told them to paint a wall, we'd have to go out and get a painter and paint a wall, and that's part of the normal process.
Understood.
Really trying to give you as much a benefit of the doubt as possible because of the amount of the fine.
Correct.
Or you can continue, it's up to you.
Can I have a brief moment with my client?
Absolutely. And I know I've never done this before,
It's okay, Your Honor.
and you've put a lot of time into this presentation.
It's okay, Your Honor.
This is an awful lot of money.
It certainly is.
Oh.
Should I come to you for?
No, for the record, I explained to the parties that I thought the presentation was not adequate for me to make a decision, and that I was giving them a chance based upon what I said this morning, and that is it's a mathematical formula to present in a method that might be easier for me to understand.
And Your Honor, I do appreciate it, I really do. And
You won't get this at the circuit court level.
I know. And I think at this point, you know, from my client's perspective and from, you know, the direction I'm receiving is that we're going to, we made in our eyes the attempt to try to cognize frame these time periods. And I appreciate and understand your position and your time and where you're coming from. But I think we're going to just move forward, and I'm going to do my best attempt at giving at least some direction to this.
Okay.
And where the outcome falls is where the outcome falls.
Okay.
So,
Well, then, why don't we go back to the initial 288 days? And the question I asked you when we were here at the bench is, if his agent was given notice
correct.
of the failure to comply with the code, why should he not be held accountable for that 288 days?
The only reason being, Your Honor, is that he had no personal knowledge other than the constructive notice. That's what I can lean on. I will say that back in October, that the city did make personal outreach to reach him. So I don't know how that contact information was obtained, but they managed to get a hold of him, and that was the first contact made in October of '22. But outside of that, it's just that he did not have personal knowledge of it.
Okay. I'm looking, Ms. Herstein put into evidence a very detailed time frame. I'm looking for when the first time, November 7th, 2022, he was on a phone call with Ms. Herstein.
It was a phone call, so it was November 7th date.
Okay. All right, please continue.
The next date that we're pointing to is the date of the violation of imposing fines, or I'm sorry, the imposition of fines through that contact, which I had October of '22, but I guess if you have the 7 additional days to take it to 280. And it would be for the same alleged reason.
You have October 22, what happened then?
The date should be to reflect the same timeline as staff, which should be November 7th.
November 7th.
Correct.
Okay. All right, please continue.
The next timeline that we're pointing to is the January through March period, which was various contractors and trying to secure professional services and get that help to get this moving. The following time period would be the October landfall, obviously, of the hurricanes. I don't have that specific date at hand, but I'm pointing to October. And the period that we're alleging is that through April of 2023, he was engaged to perform professional services in response to the emergencies, and in part, damage that was along the coast that he did not have the bandwidth, the time, the manpower, the ability to make those improvements and those changes.
I saw that in the affidavit. Could you explain what he was doing?
Sure.
It wasn't in the affidavit what he was doing.
Of course.
Okay,
So I own a large-scale disaster relief company.
okay. Could you please raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And what's the name of the company?
First Choice Services.
Okay. And so you were involved with disaster relief?
Yes, sir.
What does that exactly mean?
We do large-scale repairs and immediate response actions to save structures and assets and buildings nationwide.
Okay,
We actually put the first temp seawall at the Grand Coquina
okay.
to save that building from collapsing.
Those bags?
Yes.
Okay.
That's what we did.
We see that in here every month.
So with that being said, I mean, we had concrete trucks lined all the way up down the road for 3 days straight to save that structure, you know? So it's not like we couldn't do what the city was asking us to do. I just didn't have time. So,
Okay.
Speak to the other aspects of through that April period of what you were engaged in and doing.
on both coasts. So at that time, I'm servicing Sanibel Island, your property's right here, right in your zip code, Ocean's HM1, Ocean's 8, Grand Coquina. So there was a large period of time where I couldn't go paint a wall for graffiti. You know, I'm saving a 20-some story building, you guys are worried about some paint? I just didn't have time.
Okay,
That's
I
what-
understand. Thank you for clarifying it, because in your affidavit, you didn't say what you were doing. You just said you were doing, you were working on these buildings.
Understood.
Okay.
So moving forward from there, after Joe managed to get the bandwidth to be able to reengage and to, obviously some of these contracts had lapsed. He had to reengage professionals again to get the plans together for submittal to the city. That period we're alleging again is another 90 days to get that, also to get those plans re-up, to redo, let's get it moving again, get those permits pulled.
So you're saying the permits lapsed?
Well, not the permits themselves, no, the professional contracts.
Okay,
That's what I'm speaking to, because so much time has elapsed since the engagement of the hurricanes and the hiring of professional services, probably roughly a year prior to that.
okay. Why weren't the professional services working on the building during this time period?
For the same reason Joe is. It's the same reason it takes me 120 days to get a survey. They're all very busy, they're all being pulled in other directions, doing other work. And especially with a hurricane, you couldn't get probably any seawall contractor moving that wasn't already working. So it's the same thing is true of the professionals that would be necessary to do some of this work too. I can't speak to all of them. I understand your point. It's just, in terms of hiring those professionals, during disasters, they're all mobilized because there's work to do.
Okay, I understand. Okay.
The next period we're pointing to is again, had another set of hurricanes in 2024, had the same situation, and he could speak to those if you'd like to, those specific projects in that period from September of 24 through December of 24, if you'd like me to. But it's the same situation.
It's your presentation. Okay.
Well, for brevity, it's
Right.
it's the same alleged circumstances. After those December of 24 hurricanes, again, in January, Joe certified as a contractor to come do this work for him at the building, made outreach to the city. That's, I believe, and also dated in your in the timeline from the city up through March, and he was actively working on pulling permits, making sure the work was done. So for the full period of 25, he was actively engaged in getting it done, which would be the other alleged period of time.
So when did he actually start to attack the project?
Was it November of 22? Correct. Yeah, because if I remember correctly, wasn't that the application filed for vacant land?
The application for vacant building registration, initially, that's an annual process, so the initial one, it was in 2022.
I think it was,
for the end of 2022.
right, so immediately after that initial contact with the city.
November 16th, 2022. 17th.
And that's the summary of how we got to the 1133 days, Your Honor. And again, part of this, like you had mentioned, is the severity of the fine. You know, the gentleman here purchased the property for $475,000.
Right.
And, you know, again, it's the nature of, obviously the nature of code compliance is to ensure compliance, but it also isn't to be punitive and punish in a way that discourages folks from doing the right thing.
What's the use of the building?
It's currently vacant, but it's under contract for somebody who wants to put a car wash, correct?
Oh. Okay.
And and those folks, those buyers have been actively engaged with the city to get their plans moving and to get this property back to being in active use.
Ms. Herstein, any questions?
Yes, Your Honor. Thank you. Mr. Posey, are you maintaining that there were legal service issues at any point? Because you said that the owner didn't know, I believe. Are you maintaining that there were legal service issues at any point in this process?
Just to clarify, do you mean service of process?
Yes, according to Chapter 162.
I think in terms of statutory requirements, I presume you guys would have followed your direct noticing.
I believe so, at each point. I believe so. So are you're not maintaining that there were legal service issues?
I'm taking no position either way.
Okay. We have passed 30-day marks within which that could have been appealed, just to clarify, but I just wanted to know if that was your position. I believe that you said that the owner didn't know. Is that correct? And that that's the bulk of the reason that you were wanted to strip away days from the fines?
The personal knowledge wasn't made until the city made an outreach to him personally on November 7th, 2022.
Okay. We would like to direct you, if you have the packet available, to page 4A-4.
I actually have it up right here.
After the listing of the violations, beginning on the previous page and going through to the top of this page, the very first entry, July 7th, 2020, the current property owner purchased the property after having had conversations with me about the car wash portion of the building, the storefront portion, and the requirements for vacant building registration and obtaining a certificate of compliance vacant property. Please tell me how that doesn't relate to the owner being aware of the issues. And that's from day one, that's the very first entry in the code case in 2020.
I would imagine that his impression is the filing of a registry is just simply a matter of course or some administrative action, I would presume. Did you speak to code compliance issues at that time?
Absolutely. We talked about all of these things that were happening.
With a active code compliance case?
This was how it first started.
Well, I understand, but.
And at that point, good service would not have been achieved. It would have been achieved later. What I'm trying to demonstrate is from the very first entry about this code enforcement case has to do with speaking to the owner regarding the property.
Which was prior to his ownership, correct?
Yes, indeed.
Was any outreach made after that?
Absolutely. The
To
notice
him
of
personally?
violation, yes. For each of these hearings that we've had, the initial hearing, the first compliance hearing, absolutely. Good service was achieved for each of those.
Personal outreach was made to this gentleman.
Yes, through mail, which is according to Chapter 162. And Mr. Messina was the registered agent, listed as the registered agent at the time. I'm not sure how the Chapter 162 perfectly contemplates getting service to an owner through pathways, one of them being.
I'm just making, and again, I'm not trying to belabor the point, but you had personal contact with this gentleman early 2020, and the only other contact that was made personally to him was October of 22.
by phone or by, I mean,
Yeah.
that's not the only way to make contact. In
Okay, I
fact,
get-
that's not a statutory,
Oh, I understand.
legal way to make contact.
I understand. I understand your point, and it's, right, and it's well taken, I understand.
Okay. Further, on 4A-128, there was a letter that was addressed to, after an inspection took place, with a number of representatives for the property. And I believe that the property owner was present at that inspection. That was the certificate, 4A-128. There's a letter generated that lists the interior deficiencies, November 21st, 2022.
He alleges he wasn't there.
Okay. There were at least 3 representatives, one of whom was listed as the registered agent for the property, which is for mail purposes, but still, the person who was reaching out at every point about the notice of violation.
The owner was not there.
But still, just to reiterate, you're not alleging that there were any service issues?
I have no position other than the owner was not engaged or made aware of the issues personally.
Does this property owner who's present today, is he a licensed contractor?
Currently, yes.
And would he please make his license number available? Does he have a card or something that he could?
Can I ask the pertinence of the question?
I am not aware up to this point that he is a licensed, Florida state licensed general contractor, so I was just trying to make sure, because what you were saying was you personally were busy for these 5 years and unable to perform rectification for this property. So I just wanted to make sure that all of those I's were dotted and T's crossed, because I'm not aware of your status as a general contractor.
I'm licensed in 19 states, so we can get our license number over to you. I'll have my office email to you. So do I know my license number offhand? No.
That's
One
fine.
of those is
That's fine.
Florida.
Yes.
Okay, thank you. Thank you. I have nothing further at this time, Your Honor.
All right.
I have nothing further.
Mr. Posey, last word.
Other than, just the disproportionate amount of this fine and the nature of co-compliance. And I understand staff's position and how the lack of, in their eyes, that the staffs have to pay, and it's just, the goal of co-compliance is to ensure compliance is achieved.
Right.
It's not to be limited.
I would agree with you. I would agree with you. That's why I offered Mr. Storch a continuance last time, and you this time. All right. In looking at this, I have to look at the entire picture. It's true what I said about the mathematics and what I can do. I note that the administrative fees of $149.09 have not been paid as of yet. They were ordered to have been paid by the end of April. There is currently an accrued fine of $297,000 on this property, which was purchased for $475,000. I've looked at the totality of the circumstances. Legally, if your agent has notice, you have notice. I'm sorry that you hired the wrong person, but there's nothing that I can do about that. What I do find persuasive is the fact that while you were trying to bring the building compliant, we were hit by 4 named storms, and I can understand that that caused a shortage of materials and manpower and everything. So what I'm going to do is, for those 4 named storms, I'm going to deduct an entire year, 365 days. So the fine will be $206,250. I've removed $90,750. Order that the $149.09 of administrative fees and the $79.69 for a total of $314.31 be paid within 7 days. Thank you very much, gentlemen.
Appreciate it, Your Honor. Thank you so much.
Thank you. Is that clear, ladies? You need my math or anything? Okay. All right. Ms. Herstein, very well done. Really should have gone to law school.
Absolutely not, Your Honor.
You really should have, although I actually like you, and I guess saying that is, cursing you with a life that you probably don't deserve. All right, does anybody else have any other business before the code enforcement magistrate? I guess I can't say court. All right, our next meeting will be July 17th at 9 a.m. And then the August meeting will be August 14th at 9 a.m. And September is scheduled for September 18th at 9 a.m. Nothing else? We're adjourned.
Thank you, Your Honor.